the warden know we're in a public parking lot, man. We're just here to get content for our news story. Then we're going to get up out of here.
What's the news story about?
It's private right now. I can't disclose it.
So, part of dispelling my alarm that you're prowling and loitering is identifying yourself. Not doing so will constitute obstruction, and you will be arrested.
So if I don't identify myself, what's going to
You will
happen?
be arrested for obstruction.
So you're turning a constitutionally protected activity into a crime. Can I speak to a supervisor? Right now, we're engaged in constitutionally protected activity.
I'm in a public parking lot, okay? Exercising my constitution protected activity. I'm not identifying. If you want to arrest me, arrest me. What's your reasonable, articulable suspicion that I've committed?
That you are here in a manner that is not normal.
So the First Amendment's not one. If you tell me
Okay, so the
you're
sergeant's
going to
coming.
charge me with a crime, that I'm under arrest, I will go peacefully. I will give you all my information.
Because I don't have to.
Am I detained? Okay, I'm detained. Just want to make sure that's clear. We're detained. I know we're right in what we're doing, because had we not been, you would have put me in cuffs and arrested us already.
I train and instruct law enforcement and military all across the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, etc. And so here we see a very interesting dynamic. Seems like we have some First Amendment auditors, petitioners, activists, sovereign citizens, whatever the flavor they may be today. And they appear, based upon what we can see in the background, based upon the mention of a warden, based upon the personnel that show up. We have these petitioners on a correctional facility, and we see an officer trying to spin things, right? Trying to mention loitering policy, things of that nature. Is never something I understood. It's not something that I agree with. The case law on this is pretty clear. So let's take a look at the case law and what the case law says. So the United States Supreme Court has affirmed that the Florida trespass statute applied to a demonstration on the premise of a jail which is built for security purposes and not open to the public. There was ample evidence to support the petitioner's trespass convictions for remaining on jail grounds reserved for jail uses after they had been directed to leave by the sheriff. There was no evidence at all that the petitioners were arrested or convicted for their views or objectives. Again, Adderley v. Florida, 1966. And why this is important, especially to me, why this case law is particularly special, is because I do believe the petitioners are there for all the right reasons. So if you actually go and you flush out why these people were at this correctional facility, it's because they were trying to end segregation. They wanted to end segregation at the jail. And so, as a person of color, that's nothing but admirable. I'm not going to sit here and tell you that it's something that's not admirable. I think that we do, and it was good that we had people out there at that time that were willing to stand up for the rights of all people. So you're not going to sit here and get me to tell you that, I always agree with every decision that's made from a public policy standpoint, or from why or why not discretion was made, or why not somebody was charged, etc. That's not the point of this channel, and that's not something that I'm going to try to parse, right? Because again, I think that people standing up against segregation was an important deal. Now, with that being said, we also have to realize that the Supreme Court is charged as the highest court authority. It is the court of last resort, so to speak. So when we really look at this, we have to really understand that, again, the Supreme Court gets to make these decisions, and the Supreme Court in Florida, Adderley versus Florida, 1966, made their decision. And so for this, I think that, again, law enforcement needs to be better trained. They need to understand this. Again, the officer looking for some kind of loitering statute or policy just is ridiculous, man. Know the case law. Case law is pretty clear. And it seems like the journalist, First Amendment auditor, whoever he may be, seemed pretty reasonable. He's like, well, tell me what crime you think I'm committed, and I'll listen. I'll give you all my information. Well, that could have been as simple as the officer being empowered with knowledge and being like, here's the deal, man. I get why you're here. I appreciate you here. I appreciate you flexing your First Amendment rights. I just want you to know that when it comes to the jails, when it comes to correctional facilities, the Supreme Court has held and affirmed in Adderley versus Florida 1966 that you can be trespassed from the property. At this time, the warden does want you trespassed from the property, so I'm going to give you an ample amount of time to leave the property. If not, you will be arrested pursuant to the trespass. Pursuant to Adderley versus Florida 1966, which is also held that we are not arresting you or taking enforcement based upon your views or objectives. It is simply for the trespass statute. And so if you're able and you're acknowledged with the power to know what the case law says and why it says that, I think that situation could have been totally, de-escalated to a situation where it's a win-win for everybody.